Questions?
Thank you very much, Mr. Chairman, Mr. Lieberman, Mr. Pugliarese. Thank you for your responses to my colleague, Mr. McKinley, in regard to what we could actually do to lower the price of gasoline for consumers. And I would have to agree that a number of those would work, particularly the expectations. As you said, Mr. Lieberman, when you have the President of the United States, first as a candidate, and then on day one saying, we're not going to have any more drilling, we're not going to do the Keystone XL pipeline, how can you then expect those folks who normally would do the exploration, the drilling, the investment in new equipment, new refineries? As I understand it, and tell me if you've heard this as well, our refineries are actually operating at about 93, 94%, which is about as good as you can get. Is that your understanding too, Mr. Lieberman?
Yes, it is. And one of the things refineries are struggling with is CAFE greenhouse gas standards for vehicles that will essentially require electric vehicles. So there's regulations that would constrain the amount of gasoline that can be used in the future effectively. And that raises questions about whether investing now in more capacity would be worth it.
Yeah. And somebody used the term delusional earlier, and I would concur with that as well. All right, let me switch gears and let me go to something different. Let's talk about the weatherization. Now, Mr. Lieberman, I like weatherization a little bit better than you do based on your earlier comments, but I am concerned about this repair or reconstruction of a home before you get there. And I know that the bill has on page 4 a limit for average cost per unit basis, but in some parts of the country, and that may include parts of my district, if the home is in disrepair, you might hit that average cost based on prices in more expensive areas of the country. The average cost might actually mean that you invest more money in the home than the home is actually worth, even after repairs. Can you comment on that? Should we have something in there that if we're going to do it? I know you don't like the program that much, but if we're going to do it, shouldn't we have something in there that says that it should be a percentage of what you expect the home would be worth after you've done all this work on it?
Yes, I think that would be a good safeguard to improve the bill. I will say generally about the weatherization program, and this is just anecdotal evidence, there is a fair amount of waste that goes on. I think something less than 100 cents on the dollar has been spent wisely. A lot's been spent on the program. One would think that much more wouldn't be needed to be spent if the previous amounts were allocated more wisely. I don't know the specifics of your particular question, right. But again, I think with the tremendous amount of funds that weatherization is already getting, I think there ought to be increased oversight. Right,
I agree with that. H.R. 5292 on the agenda today is a common sense bill. I support that. It deals with making sure that if somebody has gotten a DOE loan in the past, that and they've defaulted, they can't get another one. Do you think we should also say that for not only, Mr. Lieberman, not only for DOE loans, but for loans of any type from the federal government, that if somebody's defaulted in the past, they shouldn't be eligible for a new DOE loan? Yes or no?
Yes.
Okay. And then I want to move on to something that I think is significant, and that is I think we probably also ought to have civil penalties for federal employees who knowingly and willfully violate the law, because that's what I believe happened in the Solyndra situation. Everybody heard about the $527 million that was spent in Solyndra. That isn't what got my goat. My goat was the $95 million that was given to Solyndra subsequent to their default on December 1st of 2010. And when the code specifically says, I'm reading right now from the code, the obligation, that would be the DOE loan, shall be subject to the condition that the obligation is not subordinate to other financing. And in that case, I believe that some parties at DOE decided to subrogate the law and disregard it because the law clearly said after default there weren't supposed to be any more monies. They then came up with this plan to subordinate $75 million, which cost the government or cost the people $95 million to outsiders they did so with a series of emails back and forth, and one of the requirements on default was that you talk to Treasury and Department of Justice. When this scheme came forward and they mentioned it to Treasury, Treasury actually sent an email back at the time that said, hey, we don't think you can do this. Maybe you should check with the Department of Justice, but they never checked with the Department of Justice. I suspect that's because they didn't want to find out they weren't allowed to do it and have somebody from Justice saying that. Don't you think a civil penalty added in there if somebody willfully and knowingly violates the federal law passed by Congress, don't you think that would help improve the DOE program as well?
That would make for a better program than without it.
Thank you, Mr. Chairman. I yield back. Thank you, Mr. Lieberman and others.
The gentleman yields back.